What's going on, everyone? What's going on, everyone? Welcome to the Turf Pest Management Chapter 3, which is all about federal and state pesticide laws. Specifically, the state laws that we're going to talk about are Michigan. This is for the Category 3A. Category 3A for commercial pesticide applicators. I was blanking out there for a second. And this is all about the laws. Now, at the beginning of this presentation, the federal laws are going to cover every state. And then we're going to get into some more Michigan-specific laws. Actually, this is my second time recording this. I did this on a different platform, and it did not work. It was super laggy. The audio was bad, so we get to do it again. All right. So let's dive in. If you don't know who I am, my name is Austin Douglas. I'm the owner of Ditch the Itch, Poison Ivy and Mosquito Control Services here in Goodrich, Michigan. I'm also the owner of Elevate Applicate. Elevate Applicate is all about education and educating pesticide applicators. If you are a Michigan pesticide applicator and you would like some credits to renew your license, you should check out our website. It's elevate-applicate.com. And if you want to check out our current seminars that we have and what sort of credits we have available, go to elevate-applicate.com/current-seminars. And then that'll tell you what we have and how you can renew your license at probably the most affordable rate. So without further ado, let's dive into this. Okay, I'm probably going to disappear at some point when I'm start to cover up some of this stuff. But the objectives for this chapter would be to describe state and federal laws that govern the use of pesticides, handling and storage of pesticides, understanding the legal responsibilities of pesticide applicators, both on the federal and state levels, and then also understanding the posting and notification requirements for commercial applicators certified in Category 3A. So let's dive in. I'm going to disappear. See ya. All right. So we have the federal regulations. First and foremost, we have the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA. Now, this is going to be kind of a review from the National Corps, but it's because they really want you to know these laws. And I guarantee that if you're studying to take your exam, they will test you on some of this stuff. The FIFRA was enacted in 1947, and that is to regulate pesticides. The EPA is the overseeing government agency. And what does it regulate? Well, it regulates the registration use, the handling, the storage, transportation, sale, and disposal of all pesticides. And it also states that all states may provide EPA-approved certification programs and the agency to enforce the regulations. Here in Michigan, the Michigan Department of Agriculture and Rural Development, otherwise known as MDARD, has the partnership with the EPA to enforce FIFRA regulations. So FIFRA basically determines that pesticides are broken down into two classifications. One would be general use. These can be purchased and used by anyone without restriction. Then we have restricted use, which is only purchased and used by certified applicators or under the direct supervision of a certified applicator. Additional information on FIFRA can be found at the National Pesticide Applicator Corps Manual. So if you want to know more, it dives a little bit deeper into that in that manual. We have the Endangered Species Act, which is a federal law. And this is to protect animals and plants that have been classified by the EPA as endangered or threatened. And the goal is to protect them from harmful effects of pesticides. Applications within these areas might have some special limits or requirements. Some labels even instruct applicators to consult with the EPA. And that's so that you can see what special instructions or precautions might be necessary. Over here, who you would contact would be the Michigan Department of Natural Resources and Environment, the MDNRE. They would be our contact and our consultants for our endangered species here in Michigan. There's the website right there if you want to see what sort of endangered or threatened species we have. And then the EPA also has some endangered species bulletins, and there you can find the website if you want to learn more information. We also have the Federal Migratory Bird Treaty Act. This protects all birds except pigeons, sparrows, and starlings. But if protected birds become a public health nuisance to agriculture, horticulture, or fish cultures, you can get a federal depredation permit. That'll be issued by the U.S. Fish and Wildlife, and it allows the permit holder to control migratory birds which are causing some serious damage. That permit and the U.S. Fish and Wildlife will also determine what method you can use to control them. Interestingly, red-winged birds, rusty, brewer's blackbirds, cowbirds, grackles, crows, magpies can be controlled without permits in certain situations. And basically those situations are either it's going to damage agriculture or it's a risk to public health. And as always, we want to consult our state laws because sometimes state laws can be more strict than federal laws. But state laws will never be less strict than federal laws. Federal laws are the bar that has been set. Well, it looks like this didn't do so well in translating. What this slide basically says is that beyond this point, this is going to be Michigan-specific laws. And so if you're out there in a different state and you're watching this, this probably won't be very applicable to you, okay? You want to check with your own Department of Agriculture. You want to research your own state laws, okay? So let's dive into the Michigan-specific laws for you Michigan pesticide applicators. All right, so we have state regulations here in Michigan. It starts out with the Natural Resources and Environmental Protection Act, Act number 451, Part 83, which is about pesticide control. And basically that gives the Michigan Department of Agriculture the authority to register or certify private and commercial applicators and prescribe the standards for certification and registration of pesticide applicators. Also, Act 451, Part 83, Category 3, pesticide applicators as commercial applicators. It categorizes pesticide applicators as commercial applicators. Basically, there's two categories of commercial applicators. You have a subclass A, which is any person, even homeowners, who use or supervise the use of restricted use pesticides for non-agricultural purposes. And then you have subclass B, which is any person who either applies pesticides other than general use pesticides in the course of his or her employment, or two, applies pesticides for a commercial purpose. So if you're out there making money with pesticides, you are subclass B. So now we have Act number 451, Part 83 continued, which lists the requirements for pesticide applications at schools or child care centers. Schools and licensed child care centers must have in place an integrated pest management program when pesticide applications will occur inside a building. When pesticides are applied to school or child care center properties, indoors or outdoors, school and child care centers providers must provide advance notification of pesticide applications to parents and guardians, which includes specific pesticide information, such as target pest and the purpose, the approximate location, the contact information for the school or licensed daycare, and a toll-free number of a National Pesticide Information Center, which is recognized by MDARD. The integrated pest management and notifications do not apply if you're using common cleaners, germicides, or disinfectants. So if they're just cleaning, then it doesn't apply. Liquid or aerosol applications of insecticides may not be performed in a room of school or child care center unless the room will be unoccupied by students or children for 4 hours or longer if required by the pesticide label. And so what this basically says is 4 hours is the minimum re-entry interval, but it can be longer if the label lists that. All right, now we're getting into Regulation 636, which is all about pesticide applicators. It establishes the standards and categories of certified applicators. It specifies pesticide record-keeping requirements. As specified by Regulation 636, commercial applicators shall maintain records of pesticide use for a specified time, depending on the type of pesticide used. You'll notice that I have shall bold and at an angle, italicized and underlined, and that's because shall is a definitive word in the law. There is no exemption. There's no, it has to be this way. A should is a recommendation, but a shall is definitive. General use pesticides will require 1 year of maintaining that record after the application, and restricted use pesticides will require to keep that record for 3 years. So as far as maintaining and keeping the records, if you can apply a general use pesticide, then you don't have to keep that information beyond a year. But if you have a restricted use, then you have to hold on to it for quite some time. So I recommend to look for general use if you at all can. It's going to save you on some paperwork and some storage of paperwork. All right, now we have Regulation 636 continued. I'm going to say Regulation 636 a lot, so just be ready. So this requires all records to contain the following information: the name and EPA registration number of the pesticide applied, the concentration of the pesticide applied, the amount of pesticide dilution that was applied, the target pest, the purpose or the crop site, the date of the application, the address or location of the pesticide application, and the method and rate of the pesticide application. Pesticide records must be made available upon request of MDARD, and if they ask for them, you have to give them to them. These are some screenshots of some checklists that MDARD provides to us as pesticide applicators, and it's basically a checklist to make sure that you can double check what you're handing to clients is the correct information. Again, I would recommend that you get really familiar with the Michigan Department of Agriculture's website and the Plant and Pest Management Division specifically on the Department of Agriculture's website here in Michigan, because it's going to have a lot of information, all the laws, anything that you need to know. Regulation 637. So this is a huge regulation. Basically, Rules 1 through 3 are the definitions and terms used throughout the regulations. Rule 4 is the legal standards for pesticide use. And that would basically be pesticide applications must be made in compliance with the following provisions. Pesticides must be used in a manner consistent with their labels. Applications must be made so that off-target discharges are avoided. Pesticide application equipment must be in good condition to prevent leaks or other discharges. Application equipment must be properly calibrated, and pesticides must not be used when weather conditions favor off-target drift. Commercial applicators who mix, load, or use pesticides in any way must have accessible spill kits. And so this right here is basically, you have to have good quality equipment. You can't be leaking while you're driving around. You have to have spill kits just in case. You have to follow the label, and you have to reduce your drift. It's pretty simple, but, it is the law. So continuing, before applying pesticides, the applicator must identify any sensitive areas adjacent to the target area and use appropriate precautionary measures to prevent the direct discharge of pesticides to those areas. So what do you have around you? Is there a school around you? Is there a neighboring property? Is there a swimming pool next door behind a fence? You need to be aware of where you're applying pesticides. Vehicles used to transport pesticides must have the business name, telephone number, and address, or the U.S. Department of Transportation number, or the licensed applicator firm printed on the exterior. Rule 5 of Regulation 637 establishes a registry of persons who must be notified before turfgrass or ornamental pesticide applications occur on adjacent property or any property located less than a particular distance away from the treated property as determined by a physician. So the reason for that is because there are some people who are can get really sick if exposed to certain types of pesticides. And so if their doctor says basically you need to be on the registry, and if somebody's making an application within this distance, it could affect your health. And so those people need to be notified so they can take the right precautions to stay healthy. Okay. Applicators certified in 3A and 3B are required to notify these persons on the list if pesticides other than general use or ready-to-use pesticides are applied on a property address listed on the most recent registry. So basically that's restricted use pesticides. You have to notify them. I would still probably notify them if I'm using general use, just out of a common courtesy, because if it is the same product and it can cause them harm, then I would rather not cause them harm, if that makes sense. You want to refer to the MDARD website, and that's where you can get the most up-to-date registry, and it's only available upon request. They don't just hand this out like candy. So something to be aware of. So Regulation 637 continued. Rule 7 requires pesticide mixing and loading operations that occur more than 10 days in a calendar year occur on a loading and mixing pad that complies with the following. It has to be constructed of impervious materials. The pad must be bermed, curbed, sloped, or designed to contain spills, leaks, and releases or other discharges generated during mixing and loading of pesticides to prevent pesticide release into the environment. Pesticides or pesticide-containing material are collected by the pad, must be contained either by the pad or drained, pumped, or transferred to an additional impermeable above-ground holding tank or reservoir until used or disposed of in compliance with applicable laws. That was a lot. So that's all basically saying that you have to have a pad that can contain the spill. And if there are materials that are going to be on the pad, they have to be collected and you have to be able to put them into a tank. So that way you can dispose of them as hazardous waste. Mixing and loading cannot occur unless a primary shutoff valve or switch is within immediate reach of the person doing the mixing or loading. Handheld equipment is exempt from mixing or loading pad requirements. So if you have just backpack sprayers, you don't need to follow these rules, this law in particular. But it's always good to have that, right? So that way you're safe, you're keeping the environment safe. And if you do decide to invest in more equipment and you do need to have that, you have it, right? So continuation of Rule 7 requires that washing and rinsing of pesticide equipment must be performed on a similar pad to mixing and loading pads. But again, this does not apply to handheld equipment. Rule 8 of Regulation 637 discusses most acceptable manner to handle excess pesticides or pesticide-containing materials. Basically, you have to follow the label instructions, and you would want to apply the pesticide or pesticide-containing material to the labeled site so that the total rate of application of active ingredient does not exceed directions of use as directed by the pesticide label. Pesticide-containing materials may be used as dilutants or in subsequent mixtures of pesticides if dilutants of the next pesticide application of such mixtures are in compliance with the above. So you can use your rinsate or what you have left over in a different mixture, but you can't go over the labeled rate. Okay. And then I had a little bit of dyslexia here on this highlighted section. It's Regulation 637. I've been saying 637 a lot, and for some odd reason I wrote 367, but it's Regulation 637. I highly recommend you go to the MDARD website and actually read this law. I know the laws are probably one of the most dullest things to read and learn, but it's really going to be critical for you to know this information. You don't want to break the law because you can face some serious fines. Okay, so Rule 9 covers personal protective equipment, or PPE, and it requires the pesticide applicators to follow the label instructions in regards to PPE. It also sets the minimum PPE requirements for chemical applicators. Unless the label states otherwise, applicators must wear the following performing pesticide tests: long pants, footwear that provides protection from exposure to pesticides being used, long sleeve clothing. However, you can use short sleeves, but you have to have soap or water or other protection that is immediately available and provides similar or greater protection and is not prohibited by the label. And then also you want some chemical resistant gloves. Generally, most labels are going to say 14 mils, those green gloves that you see guys wearing. Those would be the gloves that most of you are going to wear. Rule 10 of Regulation 637 discusses pesticide drift considerations. This is going to be primarily outdoor applications that we're referring to. It specifies that drift is anticipated due to atmospheric conditions and the nature of the application, right? We're outdoors. Outdoors is an unpredictable environment. It's not perfect. It's not a laboratory. Things are going to happen. Wind is going to blow. And it can change directions, which can change where the drift goes. But applicators must have a drift management plan in place. The plan must include specifications to obtain and secure informed consent of residents in the affected area before making the application. The Michigan Commercial Applicator Core Manual Addendum contains a sample drift management plan. That's a good one to look at. Now, I'll also add that I do have a a general document that is to obtain consent. And it's basically a document that says, hey, we're going to apply pesticides. There's probably going to be drift on your property. Are you okay with that? Do you consent to this occurring? I'm not going to classify it as a legal document. If you want it to be a legal document, then I would take it to an attorney to make sure that he reviews it, revises it, and makes it a legal document. But it is a sufficient as far as obtaining consent and people saying, yeah, I consent to that. And then you have it in writing, and then that could save you some potential lawsuits in the future. But again, it's not a legal document unless you take it to an attorney. He revises it and says, yeah, now this is a legal document. So if you want that, I do have that. I'll put a link down in the description below of this video. You can download it, and then you'll have it, and then you'll be good to go. So let's keep moving on. All right, Rule 11 talks about posting of certain areas treated commercially with pesticides and notification of the public before right-of-way and community pesticide applications. Does not apply when only general use or ready-to-use pesticides are applied. So a lot of these are more for restricted use. Commercial applicators must place a lawn marker sign immediately following a broadcast, foliar, or spot application to an ornamental or turf site other than golf courses or farm production. Disappear. So this is what those signs look like. If you're driving around in Michigan, you will see these everywhere in a lot of neighborhoods. And these are the requirements for the sign. It's got to be a max size of 4 inches high by 5 inches wide, made of weather-resistant material. It's got to be supported by a device, basically a stake that is going to keep it 12 inches off the ground. It's going to be two-sided and printed the same on both sides. Caution is in 72-point font. Pesticide application is in 30-point font. Keep off until dry in 30-point font. And then it says, shall contain a 2-inch diameter circular illustration that depicts adult and child walking a dog on leash with diagonal line across the circle and the statement, customer, please remove after 24 hours in 11-point font. So they are super specific when it comes to this. There might be a question if you're studying to take your 3A exam on this, as far as, like how big should it be? What are the dimensions? How big should caution be? They might test you on that. But yeah, it's really interesting that they have it this specific, even down to the dog with the leash. They have it this specific. Okay, so Regulation 637, pesticide use continued for public and private golf courses. Notification of pesticides shall be provided on a poster or placard that is constructed of all-weather material. And it has to contain a general statement, from time to time, pesticides are used to manage turf or ornamental pests. It also has to state that questions are to be directed to the golf course superintendent or designated representative. And this has to be displayed in prominent areas such as the pro shop, the locker room, or the registration area. Continuing on with these golf course rules, at the time of application on the golf course, the information has to be posted at the 1st and the 10th tee. The reason for that is because you could play 9 holes. And so if you're teeing off on the 10th tee and it was only posted at the 1st tee, well, you don't know that there was just a pesticide application being made. So if you're playing the back 9, you start on the 10th tee, and that's where you get notified. So they put at the 2 points at which you would start playing. It also needs to contain the date and the time of the application, the common name of the pesticide that was being applied, the areas treated, any reentry precautions, and name of the person on who to contact. These posting requirements remain in effect until the reentry requirements have been fulfilled. So now we're going to talk about the regulations with Regulation 637 for right-of-way applications. Commercial applicators shall not make a broadcast or foliar application of pesticides for community or right-of-way pest management without reasonable efforts to provide notification prior to persons who own or reside on a property that is within the target area or the authorized representatives. The reasonable efforts include personal contact, advertising in at least one newspaper of general circulation within the area of application. That notice should be placed or shall be placed in the legal notification section. and also prior written notification works as well. So again, what needs to be on the notice for right-of-way applications? The name, address, telephone number of agency or individual in charge of the program, the brand name and active ingredients of pesticide used, the method of application, the scheduled dates of applications, the name, address, phone number of the contact person responsible for supplying updated information concerning the application for anyone that requests it, and any reentry restrictions. Treatments of multiple use areas. So a multiple use area would be like a park or common areas in a condo complex or apartment complex, things like that. The applicator must post information for not less than 24 hours at the primary points of entry. I guess this would also be a mall. It has to contain the name, address, telephone number of the agency or individual in charge of the control, of the control program, the brand name and the active ingredients, the date of the application, and any reentry restrictions. Rule 12 is all about the applicator service agreements. So if you are a pesticide applicator and you are going to be working at people's homes, you need a service agreement, and this is going to be all about what you need. It requires that commercial pesticide applicators to enter into an oral or written service agreement with customer authorized agent. I do not recommend going into an oral agreement. That to me sounds like it's going to be a lawsuit. I highly recommend that you go into a written agreement, just because that way it'll be in writing. The service agreement must contain customers' consent to service, name, address, telephone number of the company providing the service, the approximate schedule and frequency and duration of the anticipated services. When pesticide applications take place, the pesticide applicator must leave written information to customers. This includes the name, address, phone number of the company providing the service, the full name of the applicator, a general description of the target pest to be controlled, a list of pesticides applied, including the common name of the active ingredient, time, date of the application, precautionary warnings, and reentry requirements. Prior to service, commercial applicators must provide a risk-benefit information. This is also known as RBI. The RBI must include a definition of a pesticide, description of how pesticide works, reason for use of pesticide, and general toxicity information. Now, in Michigan, we do have to have that. I do have an RBI document. If you want that, you can find it. I'll put a link down in the description of this video, and we'll make that available to you so you can download it and you can have it so you can give it to your clients if you so wish. All right. If requested by the client, the applicator is required to provide all of the following information: pesticide product labels, material safety data sheets. These are also known as SDSs or MSDS sheets, EPA fact sheets, and document that specifies the rate of the application of active ingredients applied. So I'm going to zoom out here. A little quick hack. So this is a binder of mine. You can't really see it because it's blurry, but this contains all of our pesticide information, all our SDSs, all of our labels. Every single truck of mine contains one of these. It takes some time to make, print out all this information, but I mean, it's full of everything. And why you would want to have a binder like this in your vehicle with all of the products that you use is because imagine if somebody was walking down the street and they get a whiff of a chemical, say like 2,4-D, and they're concerned that they're getting poisoned. Rather than saying, oh, we have to wait until we get back to the office to send this to you, you can say, oh, hold on, ma'am, I'll go get you a copy of the label and the SDS sheet so you can have it right now. And by doing that, you can calm somebody down pretty quickly when you explain them and you understand what the label says and you understand what the SDS says. You can explain it to them and it'll calm them down hopefully pretty quickly. Versus if you were to wait and go back to the office, now they can start to think, they can get angry, they can go to social media. A lot of things can happen, and you don't want to be slandered, have your name out there in a bad light. So if you can reduce that by just having the labels on you, on your persons, that's a better outcome in my opinion. Okay, so pesticide use. Rule 13 talks about the misrepresentation of pesticide safety. And what this means is you cannot make claims that any product or pesticide is endorsed by the federal or state governments. You can't make comparative statements of pesticide safety, such as contains all natural ingredients, among the least toxic chemicals known, or pollution approved. That was probably one of the funniest ones. And you can't make claims of absolute safety. Rule 14 requires training commercial applicators in integrated pest management and the development of an IPM program for schools, public buildings, daycare centers, and healthcare facilities. Rule 15 requires outdoor ornamental and turf applications of liquid spray pesticides may not be made on school grounds or within 100 feet of occupied classroom buildings during normal school hours or when grounds are being used. The applicator must notify the school's building manager regarding any pesticide label reentry intervals that are required. Rule 16 establishes a registry of certified organic farms. Why that's important is because if you're applying a pesticide and it drifts or gets volatilizes, goes onto a neighboring property, and it's an organic farm, you could ruin their certification, and then that could result in a lawsuit, which is not what you want. So you need to know where those farms are. Rule 17 details the penalties and the violation of local pesticide ordinances. So again, in conclusion here, you will want to visit the MDARD website and double check the laws, read the laws. You can download all the laws there. Go to the Plant and Pest Management Division, download it. And what we talked about earlier, if you need a consent form, a document, I have one available. It's a general form. Don't take it as legal advice because it's not. It's just a simple document that was made, given to me for free, and I want to give it to you for free. You can find that down in the description. I'll put a link to it. And then also the RBI information. You can also get that for free. And I'll put that in a link down below as well. Other than that, that concludes Chapter 3 of Turfgrass Pest Management. And yeah, it's a lot of laws. You got to know the laws. You can't be exempt from the laws. So other than that, I will see you guys in Chapter 4 here in the coming days. So I hope that this is helping you. Other than that, you guys take care, and I'll see you shortly.